Recently, the Delhi High Court has given decision on prohibition on Sapinda marriage. Let's see what is it. Delhi High Court in the case of Neetu Grover versus Union of India 2024 has rejected a challenge to the constitutionality of Section 5 Clause 5 of the Hindu Marriage Act 1955, which prohibits marriage between two Hindus if they are Sapindas of each other. Sapinda marriage involves individuals who share specific degree of familial closeness. Why was the law challenged and what was the court ruling? Petitioner argument was that in 2007 her marriage was declared void after her husband successfully proved that they had entered into a Sapinda marriage and that woman was not a community where such marriage could be considered a custom. Petitioner challenged the constitutional validity of the prohibition on Sapinda marriages, arguing that Sapinda marriages are prevalent when there is no proof of custom. Hence, Section 5, Clause 5, which prohibits Sapinda unless there is an established custom, violates the right to equality under Article 14 of the Constitution. The petitioner also argued that if the marriage had received the consent of both families, which proved the legitimacy of the marriage, but court found no merit in her argument, holding that the petitioner did not provide stringent proof of an established custom which is necessary to justify a Sapinda marriage. The court held that the choice of a partner in a marriage can be subject to regulation. With this in mind, the court held that the petitioner did not present any cogent legal ground to show that the prohibition against Sapinda marriages was violative of the right of equality. What is a Sapinda marriage? A Sapinda marriage is one between individuals who are related to each other within a certain degree of closeness. Let's see what are the legal provisions related to marriage in India. The Constitution of India guarantees the right to life and personal liberty under Article 21, which includes the right to marry a person of one's choice. The Special Marriage Act 1954 allows any person to register and solemnize their marriage with a person of their choice. Court of India has dealt with several cases involving the marriage of person of his or her choice, like in the case of Lata Singh versus State of UB 2006. The court held that the right to marry a person of one's choice is a fundamental right under Article 21 and that no one, including the parent or the community, can interfere with the object of such marriage. In the case of Shakti Vahini versus Union of India 2018, Supreme Court held that the consensually choosing life partner is a manifestation of their freedom of choice guaranteed under Article 19 and 21 of the Constitution. What are the exceptions to the prohibition against Sapinda marriages? These exceptions are mentioned in Section 5, Clause 5 of the Hindu Marriage Act, and it states that if the custom of the individual involved permits Sapinda marriages, then such marriages would not be declared void. However, certain conditions must be made for a custom to be considered valid. The rule in caution must be certain and not unreasonable or opposed to public policy. And in the case of a rule applicable only to a family, it should not have been discontinued by the family. If these conditions are satisfied and there is a valid custom permitting sub intermarriages, the marriage would not be declared void under Section 5, Clause 5 of the Hindu Marriage Act. Let's see if the similar to sub intermarriages allowed in other countries. Let's take example of some countries. In France and Belgium, the crime of incest was abolished under the Penal Code of 1810, allowing marriages between consenting adults. Belgium maintained this legal stance even after introducing a new penal code in 1867. Portuguese law does not criminalize incest, implying that marriages between close relatives may not be prohibited, whereas Republic of Ireland recognized same-sex marriages in 2015. The law of incest has not been updated to explicitly include individuals in same-sex relationships. In Italy, incest is considered crime only if it causes a public scandal, suggesting that the legal framework takes into account certain circumstances. However, in USA, incestuous marriages are generally banned in all 50 states. However, there are variations in laws related to incestuous relationships between consenting adults. For example, New Jersey and Rhode Island allow such relationships under certain conditions. So, we have seen different countries have different marriage laws.